Bristol Legal, our show that is dedicated to issues, bringing you issues that are relevant to you, your community, your workplace. My name is Elizabeth Nowakowski. I'm a faculty member for Paralegal Studies here at Bristol Community College. Today, I'm very excited to bring you a guest that we haven't hosted yet, attorney Bob Thomas, all the way from Boston. And attorney Thomas is a former assistant U.S. It's a former assistant U.S. attorney who used to concentrate on white-collar crimes and then moved on to private practice. He co-founded a firm that is focusing on on whistleblower crimes, that is in civil actions, and it is called Whistleblower Law Collaborative.
Whistleblower Law Collaborative.
Mm-hmm. And the firm, or was it you that received the award recently?
My partner and I, Suzanne Durrell, my co-founder, and I received an award last year from Taxpayers Against Fraud, which is in this same space, for being Whistleblower Lawyers of the Year.
Congratulations.
Thank you.
Well, welcome to the program. I'm really looking forward to our discussion here on those important issues of whistleblowing, white-collar crimes, etc. So maybe to get, and also, I almost forgot, very important, I think it is, to add that Attorney Thomas is a member of the board of directors for a local chapter or Massachusetts chapter of ACLU.
That's right.
Which we met, that's why we met when you came to BCC and spoke to us on the Constitution Day. So
that's right. That's how we first met, and I'm very happy to be on that board at this important time in our country.
Thank you. So let's get started about whistleblower. Tell us about whistleblowers. Many of our viewers may not even know what the term means. What does it refer to? Where did it come from? And what does it encompass?
Sure. Well, the term is used more broadly than we necessarily use it as lawyers, but certainly in common parlance, people talk about whistleblowers as anyone who is alerting the authorities to a problem. And that's certainly how the term is used most broadly. But a subset of that overall universe of whistleblowers involves some laws on the books that actually encourage and incentivize whistleblowers to come forward to alert the government, usually. Might be the Department of Justice, or it might be the Securities and Exchange Commission, or even the Internal Revenue Service, of a problem that the government might not have been aware of. So, for example, in the securities field, if a company is engaged in, let's say, insider trading or stock manipulation, a whistleblower can file a tip with or without the assistance of an attorney, and can submit that to the commission, and they will investigate it. And if at the end of that process there's a recovery by the commission on behalf of the defrauded taxpayers, the whistleblower may get a percentage of that recovery. Similarly, a law that we use quite a lot is called the False Claims Act. And the False Claims Act actually is procedurally a little different, but it provides a private cause of action for a whistleblower who actually sues in a case that's under seal, sues the defendant in the name of the taxpayers. In other words, the money at stake with the False Claims Act is taxpayers' money, but the government may not have been aware of the fact that it was being ripped off. So this statute gives the relator, as they are called, or the whistleblower, the ability to tee this up for the government, put it in front of them and say, here's a claim, here's the evidence, here's what I know. Are you interested in joining this lawsuit as co-plaintiff? And we will prosecute it together. And if at the end of that process there's a recovery on the civil side, then by law the government is required to share between 15 and 25% of the proceeds with the whistleblower. So this has become one of the government's primary anti-fraud tools, and it has become an area of concentration for us in the last 15 years. We've had a fascinating and interesting run being whistleblower lawyers.
And thank you. And the whistleblower laws, when did it all start? I mean, I'm sure there were laws in place before, but were there any events or special cases that prompted the government to really sort of tighten up any of the laws?
That's a great question. A lot of people are surprised to learn that the False Claims Act was actually passed in 1863 at the height of the Civil War. And the genesis of that was actually Abraham Lincoln's astute analysis that defense contractors were ripping off the Union Army outrageously and selling all manner of substandard equipment and weaponry and uniforms to the Union Army in violation of their contractual obligations. So he encouraged Congress to pass a law that would incentivize people to come forward and tell the government how it was being ripped off. And the incentive, which was in the statute from the very beginning, was, well, we'll share the proceeds with you if you tell us of the problem. And that was how it got started. As the decades passed, the conservative era of the Supreme Court, which was a very pro-business court called the Lochner Court, whittled away and poked some holes in the statute, so it fell into disuse until 1986, when during the defense buildup of the Reagan administration and the scandals related to the defense buildup, the statute was amended. Some of these legal holes were filled by amendment of the statute. And since 1986, it has been a growing enforcement tool. It's now in the realm of government contracting, it's the government's primary tool. More than 90% of the cases that the government settles are brought initially by whistleblowers bringing the case to them. So it's become a really critical area, and there's a bar of lawyers, which I'm very proud to be part of, that has basically devoted itself towards representing people in this practice area.
And which areas or industries does the Act apply to? Or is it anyone?
It applies to any industry that is involved in submitting claims against the government treasury. But there are large categories. The two largest are healthcare and defense. The Medicare and Medicaid programs, as well as TRICARE and CHAMPUS and some of the other lesser known ones, but primarily Medicare and Medicaid, are huge government programs that cost hundreds of billions of dollars, actually trillions of dollars to administer. And because of the number of claims involved, the government can't check and verify every claim before they're paid, because the system would simply stop working. So the claims are paid promptly, and then problems are chased later. We refer to this as pay and chase. The other big sector is defense. The Pentagon's budget is huge. A lot of that money goes to pay private contractors for destroyers, airplanes, tanks, GPS equipment, and all manner of things that the Pentagon orders. And there are contracting rules that govern how those contracts are administered. If there are problems of overbilling or failure to deliver or similar non-delivery issues, then the government, in theory, has a claim to bring against that contractor, but they may not know that they have that claim unless someone comes to them and says, when my company submitted this bill to you, they actually padded the bill, and here's what you should have been billed as opposed to what you were billed. So those are the two largest sectors. Transportation is a large one, FEMA relief. Anytime the government throws a lot of money at an emergency situation, that tends to be a ripe opportunity. The Iraq War was a very bad example of this, because so much money was being spent so quickly, and a lot of the paper trail was spotty. The ability of whistleblowers to have access to that information in Iraq with security needs was basically almost impossible. So a lot of the money that was improperly spent in the Iraq War was not ultimately recovered, and that was very sad to watch, but many of us were referring to it as a free fraud zone because paper-thin contracts, a lot of money moving out the door very, very quickly without a lot of control. In the healthcare and the defense sectors, these are well-regulated industries. The terms of engagement are very well understood. There are laws that these industries understand, but there are still instances of non-compliance. I like to say that 90% compliance, which sounds pretty good, in the healthcare sector still leaves you with hundreds of billions of dollars of non-compliance. Yeah. So simply because of the nature and size of the problem. So that's what we do, but the big categories are healthcare and defense.
Yes. So I want to come back to healthcare in a second. So False Claims Act really deals with claims submitted to federal government. So that's really that's what. But there's also the other part of whistleblowing in different sectors, which may not fall under this act.
That's
right. When we're talking about maybe financial fraud. So I'm thinking of, situations like Madoff or, Madoff was SEC, so maybe that would actually fall under it. But Enron, where you're talking about financial fraud or misrepresentation, where does that fall in?
That's a great question. There are other more recently enacted whistleblower programs, largely in response to the financial crisis of 07-08, that are in place to incentivize people to alert the enforcement authorities of when there is stock manipulation or a Ponzi scheme or tax evasion or commodities fraud. So the CFTC, the Commodities Futures Trading Commission, has a whistleblower program. If someone is engaged in fraud related to blockchain technology, for example, or some of the trading derivatives that are related to that, there is a mechanism where you can alert them by filing a tip. Similarly with the SEC, it's a tip statute. So unlike the False Claims Act, it's not a private cause of action. It's not an actual lawsuit. It's more of a tip that someone can fill out and say, this is what I'm aware of. Now, there's an important distinction. Because the False Claims Act has a private cause of action, if the government declines it, the whistleblower can actually, with their lawyers, still go forward on the government's behalf. With these other programs, which are more tip statutes, if they decline to prosecute it, that's the end of the road. So the third one in that category is the IRS program. So at about the same time, the IRS enacted a whistleblower program that says if you're aware of a high-level tax evasion scheme, you can alert the IRS to that, and you'll get a percentage of money recovered. So whether it's the SEC or the CFTC or the IRS, there are some of these tip statutes that are in place to essentially help the government have additional eyes and ears to be alerted to things that they would not have otherwise have known of. Of course, on their end, with the tip statute, the issue is volume, because they can get tens of thousands of tips per month. So that requires that they have a whole triage system in place. So the lines of communication between whistleblowers and the agencies are very different in those programs than they are with the False Claims Act, where we actually file a lawsuit and have an independent right to prosecute it. There we have to be talking to the government because we're giving them a case that's filed in court, we're delivering a witness to talk to them, we're giving them documents, and we can prosecute the case if they decline to. So that's a much more robust line of communication than these other tip statutes. But all of them are driving in the same direction, which is we want to incentivize integrity. We want to incentivize people to have the courage to speak up when something needs to be identified.
When we talk about healthcare fraud, there's a lot in it, right? So
absolutely.
There are different components of it or different parts. Can you just sort of maybe list some of the, maybe
Sure.
not necessarily examples, but just what falls into, the drug companies, the distribution,
Yeah.
How can we look at it holistically?
There are a number of specific laws in addition to the False Claims Act that apply. The most well-known ones are the Anti-Kickback Act. That's a criminal statute that basically says you can't offer financial inducements to physicians or to providers in order to change their behavior, their purchasing behavior. So hypothetically, if a medical device company were to offer doctors extra cash on the side, if you'll just use our artificial knee as opposed to our competitor's artificial knee, that's illegal, that's a crime, that's a bribe. Similarly, a doctor can't say, well, what are you going to give me for your service? I want some special consideration. The doctor can't ask that either. The point of this is we want doctors to have their medical judgment not be unduly influenced by the power of money. And of course, doctors will tell you that they can't possibly be bought off, but we all know that doctors are human beings and they succumb to this as well as other people do. So the Anti-Kickback Act is a powerful tool. There are civil laws. The off-label marketing prohibitions are very important in this space. The FDA approves drugs for particular purposes and in particular dosages, but they may not approve them for other purposes or other dosages, even though we give doctors the right to prescribe off-label. So the rule is that marketing, the manufacturers' marketing teams can't sell, they can't market off-label, even if doctors can write prescriptions off-label. So that's an area that is the subject of quite a lot of enforcement, particularly in the last 15 years. There's laws called the Stark laws, which are designed to slow down or prohibit self-referral practices in the medical profession. So if a doctor decides to buy X-ray equipment and own the X-ray equipment, it's designed to slow down the temptation to suddenly refer all your patients to your own X-ray equipment to increase your billings. So there are rules that govern how you can have those kinds of interrelated things. Certainly the Food, Drug, and Cosmetic Act is critically important to pharmaceutical manufacturers because it controls how things are produced, under what conditions, all sorts of patient safety, current good manufacturing practices apply that make the public feel that the pills they're getting are safe and efficacious and reliable. You're
representing whistleblowers.
Right.
But at the same time, you mentioned that there is the sealed component, there is a sealed complaint component, that you're actually suing on behalf of the government.
Right.
Can you break it down for us? And how does it work in practice? I assume you usually start with someone, your client or whistleblower coming to you asking for advice. Is that how it works?
So the anatomy of a case starts essentially with someone finding us. And they might find us from a referral from other lawyers. They might find us from people who have worked with us in the past in some capacity. They might find us from an internet search. Hopefully, if you do a search for whistleblower lawyer, we're somewhere in there. Certainly, if we search Boston whistleblower lawyer, we should be there. Even though our practice is nationwide, but we're located here in Boston. So the client finds us, and then there's quite a lot of screening that we do. We don't take everyone, as you might imagine. It has to meet our criteria, and that's a fairly stringent process. And that can be in a fairly involved conversation. We don't charge for that. We just evaluate it and give the person advice about whether this is something that we can do or not do. Assuming we decide to take it, we then spend time investigating the claim, kicking the tires, as it were, and seeing if this fits, seeing if this is something that might get prosecutorial interest. There's a lot that goes into that. 4 of the 5 of us who work at our firm used to work at U.S. attorneys' offices. 1 of us used to work at the Massachusetts Attorney General's office. So we know how prosecutors think and how they do their own triage systems, which is very valuable information. And so we try to not give them bad cases. We try to we're investing our time and money in these cases too. So we have our own self-interest in wanting to screen them well, but we also want the government to know that we take that seriously, and therefore you should take what we file seriously. And we've had a good track record with that. So depending on whether it's one of these financial tip statutes or whether it's a False Claims Act statute, case will then determine exactly how we put it together. If it's a tip, we help the client organize the thinking, organizing the claim, and then we submit it, and then it's radio silence for a while. We may or may not hear from the agencies at that point. The False Claims Act, we file a case under seal. That's designed to give the government time to look at it without having to litigate the matter. And then we are required to give them what's called a disclosure statement, which has all the material evidence that we have that is not already in the complaint. That's not filed with the court, that's just handed to the prosecutors. Then they usually interview our client, and then the conversation gets more interesting as we talk about, well, what do you think? Where's it going? How can we help? And we basically collaborate with them on how to bring the case forward and how to get to the finish line. And it's, no two cases are the same. It's always interesting. It's always fun.
And I believe when we spoke earlier, you mentioned that some cases take many years. I mean, usually litigation takes years anyway, often a year or two to come to trial, et cetera. But this is sort of another extreme, right? So,
yeah,
in some cases.
It takes a lot of patience, and we don't get paid until the end, if at all. So it's not for the faint of heart to engage in this work, but I mean, it's mostly contingency fee work, so we're very much at risk in the process. So yeah, it's a long process, and the reason for that is most typically a good False Claims Act case is going to involve something that is national in scope, which means that for the government to get its hands around the problem, they have a lot of work to do. This is not going to be a discrete little Boston problem or Massachusetts problem. It's probably, if it's going to have legs, it's probably going to be something that they need to check other parts of the country. There might be other whistleblower complaints filed in California, Florida, New York. They need to coordinate with those prosecutors. There may be claims data that goes back years and years that has to be analyzed. There may be former employees that need to be interviewed. There may be a grand jury that needs to be impaneled in a parallel criminal investigation. So the seal process and the seal extension can go on for quite a long period of time. That can be frustrating for our clients because while the case is under seal, they can't talk about it to anyone except us. So that can be a lonely journey. But ultimately, the point of all that is to give the government the time it needs to investigate a very complex matter thoroughly. And at some point in that process, they will surface to the defendant with either a subpoena or a search warrant or a phone call or something to say there's a problem, and then they're engaged at that point. And the defense may or may not learn of the whistleblower suit during that period that it's not visible publicly. But at some point, the government will usually say there is a party that has a stake in this who alerted us to it, and here's the claim. So there'll be a partial unsealing order that allows that to be shown to the defense without being shown to the public. Now the defense and the government can really engage in a more detailed way about how to handle the claim. But ultimately, in the healthcare sector, because the government has what's called exclusion and debarment capacity, which is that for certain types of offenses, they can exclude the defendant from future participation in those programs, that's a heavy sanction. So if the facts are strong enough, there's a strong incentive for companies to settle these matters, because if they roll the dice and go to trial and lose, they may lose the ability to sell their products to Medicare and Medicaid patients, which is an extraordinary, I mean, that hurts a lot of people, employees, patients, and so forth. So often if it's a good case, the government brings it to a settlement, and at the end of that process, if all goes well, our client gets 15 to 25% of whatever the government has recovered.
So is there anything that you'd like to share with us, one of them, as an example to illustrate what you deal with?
Sure. I mean, I have lots of great examples.
Oh, I'm sure. We only have 4 minutes.
Perfect.
So
well, I'll go in reverse chronological order. So our most recent settlement was a combined $885 million settlement against AmerisourceBergen, $260 million criminal fine, a $625 million civil settlement, total relator share in that case of $100 million. That involved the repackaging of oncology drugs at a so-called pharmacy, which really wasn't a pharmacy. It was an unlicensed drug repackaging facility. The idea behind that was to generate an extra vial of product from the repackaging that could be used to offer discounts to physicians to increase the company's market share. But ultimately, it meant violating quite a lot of Food, Drug, and Cosmetic Act rules about how drugs are supposed to be handled. And it meant selling unapproved drug products to very sick patients, which is why there was a criminal plea of $250 million. We're enormously proud of our client, who's a former officer of that company. He was terminated in a decision that I'm sure the company now regrets after he raised some issues, and he was let go, and he found his way to us, and we helped him, and he helped us unpack the problem. And $885 million later, that plant is shut down, and oncology patients have a greater degree of reliability about the drugs going into their veins. A year earlier, we were involved in the case against Mylan involving the EpiPen anaphylactic shock product. They were involved in misclassifying that product under the Medicaid rebate rules, which cost the government huge amounts of money and led to a $465 million settlement. It's fascinating. There's a lot of compliance in the world, and there's a lot of effort being put into compliance. But given the scale of things, even a small amount of non-compliance can lead to staggering amounts of fraud. And that's what we're in the business of trying to combat. We're not so cynical that we think everybody's cheating. 90% compliance sounds pretty good. But if there's 10% non-compliance, there's still a lot of fraud to be dealt with.
And what makes it worse is the 10% compliance financially, what kind of impact it has on human life if you're talking about healthcare fraud, when we're talking about tampering with drugs, and how do you put a number on that?
That's right, and patient safety is always one of those things that we think about, that prosecutors think about, that these laws are designed to think about. So these laws are designed to protect the patients or the investing public from things that they wouldn't have a reason to know about. You don't know if your doctor has taken money to promote and put that knee in your joint as opposed to some other knee in your joint, or that stent that turns out you didn't need, that stent in your vein or your artery. These are important medical decisions, and we don't want people making decisions for any reason other than good medicine. There are a lot of temptations in every sector because it's easy to get away with things if you want to. And that's the sad reality of what we've set up. It's not hard to do this. And most people, most of the time, try to do the right thing. But if you find yourself succumbing to temptation, it's not hard to dip your pinky toes into those waters. And then, as happens, once you put your pinky toes in, usually you go a little further. And that's how these problems evolve. People realize, oh, I billed for that extra thing and I got paid for it and nobody said anything, and well, let's just keep going. So that's what it's all about.
Well, thank you so much for coming and speaking with me today. I'm sure our viewers find it very interesting and new, because it's a niche kind of field of law, which we don't usually hear too much about. So thank you again,
Yeah.
Bob, for coming.